Happy third day of 2018, everyone, and Happy New Year. Welcome back to my channel, guys. As first week of the year, we will make sure that we are reviewing every day. There's no excuse. We should review every day in any kind of readings, in any kind of books until we will become a lawyer. Okay, guys, let's begin. UST Criminal Law Review Pre-Week Notes of 2016, Part 5. To start with, our topic for today is crimes against person. Okay, what are the essential elements of parricide as to relationship? The answer, the relationship of the offender with the victim must be, number 1, legitimate, except in case of parent and child. Number 2, in the direct line. Number 3, by blood, except in case of legitimate spouse. Okay, here's a question here from 2012 bar exam. Explain and illustrate the stages of execution of the crime of homicide, taking into account the nature of the offense, the essential element of each of the stages of execution, and the manner of committing such intentional felony as distinguished from felony committed through reckless imprudence. Here's the answer. The elements of the crime. Homicide as an intentional felony has 3 stages. Number 1, attempted. Number 2, frustrated. And number 3, consummated. In whatever stages homicide is committed, intent to kill must be established for being an indispensable element thereof. However, if the victim died as a consequence of wounds caused by an act committed with malice, intent to kill is conclusively presumed, and the crime committed is consummated homicide. Because of this conclusive presumption, lack of intent to kill is not a defense in consummated homicide. Note, in consummated homicide, the accused may prove lack of intent to kill for purpose of appreciating the mitigating circumstance of praeter intentionem. But if the victim did not die as a consequence of wounds caused by an act committed with malice, intent to kill must be established beyond reasonable doubt. If intent to kill is proven, the crime committed is frustrated or attempted homicide. If intent to kill is not proven, the crime committed is physical injuries. This lack of intent to kill is a defense in attempted or frustrated homicide. Now, for the nature of the crime. If the offender with intent to kill attempted to inflict or inflicted non-mortal wounds upon the victim, he already directly commenced an overt act to commit homicide. Hence, the crime committed is attempted homicide if he failed to inflict mortal wounds upon the victim by reason of some cause or accident other than his own spontaneous desistance. If the offender with intent to kill inflicted mortal wounds upon the victim, he already performed all acts of execution which would produce the homicide as a consequence. If death is not produced, despite the mortal character of the wounds due to causes independent of the will of the offender, the crime committed is frustrated homicide. If death is produced, the crime committed is consummated homicide. In this situation, all the elements necessary for execution and accomplishment of homicide are present if the victim dies due to the wounds inflicted by the offender with the intent to kill. Now, for the intentional felony and culpable felony. Homicide, regardless of stages, must be committed with malice. That is the general intent. And intent to kill is a specific intent. Even if there is no intent to kill and evil intent, the offender is liable for culpable felony. If the victim dies or was injured as a result of the recklessness of the former, if there is no intent to kill, evil intent and recklessness on the part of the accused, he is not liable for his intentional act, which caused the death of or injury upon the victim because of the exempting circumstance of accident. Okay, here's another question here. Cite 5 factors in ascertaining intent to kill. In the case of People versus Mapalo, GR number 172608, February 6, 2007, the Supreme Court said that intent to kill may be proved by evidence of number 1, motive, number 2, the nature or number of weapons used in the commission of the crime, number 3, the nature and number of wounds inflicted on the victim, number 4, the manner the crime was committed, and number 5, words uttered by the offender at the time the injuries are inflicted by him on the victim. Okay, here's another. State the rules for the application of the circumstances which qualify the killing to murder. Number 1, the murder will exist in any of the circumstances. Number 2, there are more than one qualifying circumstance present. Only one will qualify the killing, with the rest of the considered as generic aggravating circumstance. Number 3, that when the other circumstances are absorbed or included in one qualifying circumstance, they cannot be considered as generic aggravating. Number 4, that any of the qualifying circumstances enumerated must be alleged in the information. Here's a 1995 bar exam question. On his way to buy a lotto ticket, a policeman suddenly found himself surrounded by 4 men. One of them wrestled the police officer to the ground and disarmed him, while the other 3 companions, who were armed with a hunting knife, an ice pick, and a balisong, repeatedly stabbed him. The policeman died as a result of the multiple stab wounds inflicted by his assailant. What crime or crimes were committed? The answer? All the assailants are liable for the crime of murder, qualified by treachery, which absorbed abuse of superior strength. As the attack was sudden and unexpected, and the victim was totally defenseless, conspiracy is obvious from the concerted acts of the assailants. Direct assault would not complex the crime, as there is no showing that the assailants knew that the victim was a policeman. Even if there was a knowledge, the fact that he was not in the performance of his official duties, and therefore there is no direct assault. Another question here from 1995 bar exam. Pascual operated a rice thresher in Barangay Napnud, where he resided. Renato, a resident of the neighboring barangay Gihaman, also operated a mobile rice thresher, which he often brought to Barangay Napnud to thresh the palay of the farmers there. This was bitterly resented by Pascual. One afternoon, Pascual and his 2 sons confronted Renato and his men, who were operating their mobile rice thresher along a feeder road in Napnud. A heated argument ensued, and barangay captain, who was fetched by one of Pascual's men, tried to appease Pascual and Renato to prevent a violent confrontation. However, Pascual resented the intervention of the barangay captain and hacked him to death. What crime was committed by Pascual? Discuss. Okay, the answer? Pascual committed the complex crime of homicide with assault upon a person in authority. This is found in Articles 148 and 249 in relation to Article 48 of the Revised Penal Code. A barangay chairman in the law or as can be seen in Article 152, a person in authority, and if he is attacked while in the performance of official duties or on the occasion thereof, the felony of direct assault is committed. Article 48 of RPC, on the other hand, provides that if a single act produces two or more grave or less grave felonies, a complex crime is committed. Here, the single act of the offender in hacking the victim to death resulted in two felonies: homicide with a grave and direct assault, which is less grave. Okay. Dagami concealed Bugna's body and the fact that he killed him by setting Bugna's house on fire. What crime or crimes did Dagami committed? The answer, letter A, murder, the arson being absorbed already. Letter B, separate crimes of murder and arson. Letter C, arson, the homicide being absorbed already. Letter D, arson with murder as a compound crime. The correct answer is B, separate crimes of murder and arson. Another question here from 2010 bar exam. A, B, and C are members of SFC fraternity. While eating in seaside restaurant, they were attacked by X, Y, and Z, members of rival fraternity. A rumble ensued in which the above-named members of the two fraternities assaulted each other in confused and tumultuous manner, resulting in death of A. As it cannot be ascertained who actually killed A, the members of the two fraternities took part in the rumble and were charged for death caused in tumultuous affray. Will the charge prosper? The answer, no, the charge of death caused in tumultuous affray will not prosper. In death caused by tumultuous affray, under Article 251 of the Revised Penal Code, it is essential that the persons involved did not compose groups organized for the common purpose of assaulting and attacking each other reciprocally. In this case, there is no tumultuous affray since the participants in the rumble belong to organized fraternity. Another question here from the bar from 1993. State the effects of the reclassification of rape into a crime against person. Number 1. The procedural requirement of consent of the offended party to file the case is no longer needed because this is now a public crime, unlike when it was still classified as a crime against chastity. And number 2, there is now an impossible crime of rape because the impossible crimes can only be committed against the person or property. Another question here from the bar from 1987 bar exam. AJ, a medical student, was a boarder in the house of Mr. and Mrs. M, who had a good-looking 25-year-old retarded daughter, with the mental age of an 11-year-old girl. One day, when the couple were out, Perlita, the retarded daughter, entered into AJ's room and came near him and started kissing him. He tried to avoid her, but she persisted. They had sexual intercourse. This was repeated every time Perlita's parents were out until Perlita got pregnant. Mr. and Mrs. M filed a complaint of rape against AJ, who claimed that it was Perlita who seduced him, that Perlita was intelligent, clearly understood what she was doing, and that since Perlita was already 25 years old and did not herself file the complaint, her parents had no personality to file the complaint for rape. How would you resolve the case? Here's a suggestive answer. The contention of AG cannot be sustained. Sexual intercourse with Perlita, who is a mental retardate, although 25 years old, with a mental age of 11 years old girl, is raped. She is the same class as a woman deprived of reason or otherwise unconscious, since she is suffering from an incapacity, being incompetent on account of her mental age. The parents have the right to file the complaint for rape. Another question here. XXX, then a 10-year-old boy, requested his mother to pick up Recalde at McDonald's Bel Air, Santa Rosa. Recalde, then is 31 years old, is a distant relative and textmate of XXX. After dinner, XXX's mother told Recalde to spend the night at their house as it was late. He slept on sofa while XXX slept on living room floor. It was around 2 a.m. when XXX awoke as he felt pain in his anus and stomach and something inserted in his anus. He saw that Recalde fondled his penis. When Recalde returned to the sofa, XXX ran toward his mother's room to tell her what happened. He also told his mother that Recalde played with his sexual organ. XXX's mother armed herself with a knife for self-defense when she confronted Recalde about the incident, but he remained silent. She asked him to leave. Is Recalde guilty of the crime of rape? The answer: yes, all the elements of rape is present in the case at bar. Rape under the second paragraph of Article 266A is also known as instrument or object rape, gender-free rape, or homosexual rape. Any person who under any of the circumstances mentioned in paragraph 1 thereof shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice, or any instrument or object into the genital or anal orifice of another person. The gravamen of rape through sexual assault is the insertion of penis into another person's mouth or anal orifice, or any instrument or object into another person's genital or anal orifice. This case is found in Recalde versus People, JR number 211002, January 21, 2015. Okay, here's another question. AAA, a 67-year-old woman, was fast asleep when Bill covered her mouth, threatened her with a knife, and told her not to scream because he will have sexual intercourse with her. Thereafter, he removed AA's underwear. However, his penis was not yet erected, so he toyed with AA's sexual organ by licking it. Then made his way up and tried to suck AA's tongue. Once done, Bill held his penis and inserted it to AA's vagina. In his defense, Bill argued that during the entire alleged incident, AAA never reacted at all. Is Bill guilty of rape? The answer: yes. Bill is guilty of rape. AAA was already 67 years of age when she was raped in the dark by Bill, who was armed with a knife. A woman of such advanced age could only recoil in fear and succumbed into submission. In any case, with such shocking and horrifying experience, it would not be reasonable to impose upon AAA any standard form of reaction. Different people react differently to a given situation involving a startling occurrence. This is found in the case of People versus Justeva, GR number 199268, February 12, 2014. Another question. One night, while AAA was sleeping, XXX hugged her and kissed her nape and neck. He then undressed AAA and went on top of her and held her hands. Afterwards, he parted AAA's legs and then tried to insert his penis into her vagina. XXX's penis touched AAA's vagina, but he stopped as soon as AAA's cry got louder. He then threatened AAA not to disclose the incident. What crime is committed? The crime committed is XXX is guilty of attempted rape. Without showing of such carnal knowledge, XXX is guilty only of attempted rape. Mere touching cannot be considered as slight penetration. Since XXX did not succeed in inserting his penis in AA's female organ, he cannot be convicted of consummated rape. Slightest penile penetration is necessary. This is found in People versus Pareja, JR number 1888979, September 5, 2012. Another question here about rape. Cruz and his wife employed AAA and BBB to help them in their plastic and glassware business during a town fiesta in La Union. After fixing the wares in order for display, they went to bed inside the tents. Less than an hour passed, AAA was awakened with Cruz on top of her, mashing her breast and touching her vagina. AA's fought back and was able to free herself from Cruz. She went out to seek for help. Is Cruz guilty for the crime of attempted rape? The answer, no. Cruz is not guilty of attempted rape. The intent to commit rape must be inferred from overt acts directly leading to rape. In embracing AAA and touching her vagina and breast did not directly manifest his intent to lie with her. The lack of evidence showing his erectile penis being in the position to penetrate her, he was on top of her, deterred any inference about his intent to lie with her. At most, his acts inflicted lewdness and lust for her. This is found in Cruz versus People, GR number 166441, October 8, 2014. Another topic here is crimes against personal liberty and security. Here's a question. Aniban and Lirio are neighbors. Lirio entered the house of Aniban, laid down beside the infant child of Aniban and began chatting with her. Lirio then told Aniban that she would take the infant outside to bask him under the morning sun, but the latter refused. A few minutes later, Aniban realized that Lirio and her child were no longer in the house. After searching, Aniban found her infant child, Lirio's boyfriend, and Lirio on board a vessel. Lirio, together with co-accused, were charged with kidnapping of a minor. Are they liable as charged? The answer, yes. The following are the elements of kidnapping under Article 267, Paragraph 4 of the Revised Penal Code. Number 1, the offender is a private individual. Number 2, he kidnaps or detains another or in any other manner deprives the latter of his or her liberty. Number 3, the act of detention or kidnapping is illegal. Number 4, the person kidnapped or detained is a minor, female, or a public officer. The prosecution has adequately and satisfactorily proven that accused appellant is a private individual. That accused appellant took 1-month-old baby Justin Clyde from his residence without the knowledge or the consent of and against the will of his mother, and that the victim was a minor 1 month old at the time of the incident, the fact of which accused appellant admitted herself. This is found in the case of People versus Lirio, JR number 209039, December 9, 2015. Here's a question. What are the qualifying circumstances of the crime of kidnapping and serious illegal detention? Number 1. If the purpose of the kidnapping is to extort ransom. Note that if the victim is kidnapped and illegally detained for the purpose of extorting ransom, the duration of his detention is immaterial. Number 2, when the victim is killed or dies as a consequence of the detention. Number 3, when the victim is raped. Number 4, when the victim is subjected to torture or dehumanizing acts. Here's a question from 2014 bar exam. Sexy boarded a taxi on her way home from a party. Because she was already tipsy, she fell asleep. Poggy, the taxi driver, decided to take advantage of the situation and drove Sexy to a deserted place where he raped her for a period of 2 weeks. What crime did Poggy commit? The answer? Poggy committed the special complex crime of kidnapping and serious illegal detention with rape. All the elements of kidnapping and serious illegal detention are present. Poggy, a private individual, kidnapped and detained Sexy by bringing her to a deserted place. Said detention is illegal and is serious because it lasted for more than 3 days and the victim is a female. The special complex crime of kidnapping and a serious illegal detention with rape resulted because Sexy, the victim of the kidnapping and detention, was raped as a consequence of the detention. Article 267, last paragraph of the Revised Penal Code. Since it is a special complex crime, regardless of the number of times the victim had been raped, there is only one single indivisible offense of kidnapping and serious illegal detention with rape. Another question here. While walking alone on her way home from a party, Mildred was seized at gunpoint by Felipe and taken on board a tricycle to a house some distance away. Felipe was with Julio, Roldan, and Lucio, who drove the tricycle. At the house, Felipe, Julio, and Roldan succeeded in having sexual intercourse with Mildred against her will and under the threat of Felipe's gun. Lucio was not around when the sexual assaults took place as he left after bringing his colleagues and Mildred to their destination. But he returned every day to bring food and the news in town about Mildred's disappearance. For 5 days, Felipe, Julio, and Roldan kept Mildred in the house and took turns in sexually assaulting her. On the 6th day, Mildred managed to escape. He proceeded immediately to the nearest police station and narrated her ordeal. What crimes did Felipe, Julio, Roldan, and Lucio commit, and what was their degree of participation? This was asked in 2013 bar exam. Felipe, Julio, Roldan, and Lucio are all liable for the special complex crime of kidnapping and serious illegal detention with rape. It was sufficiently proved that the 4 accused kidnapped Mildred and held her in the detention for 5 days and carnally abused her. Since it is a special complex crime, no matter how many times the victim had been raped, the resulted crime is only one kidnapping and a serious illegal detention with rape. The composite acts are regarded as a single indivisible offense with only one penalty. It is illegal detention and not forcible abduction since it was evident that the intent was to detain the victim. As to the degree of their participation, Felipe, Julio, Roldan, and Lucio are all liable as principals. There was implied conspiracy as they acted toward a single criminal design or purpose. This is found in People versus Mirandilla Jr., JR number 186417, July 27, 2011. Note that although Lucio was not around when the sexual assault took place, there is a complexity on his part as he was the one who drove the tricycle at the time the victim was seized, and he returned every day to bring food and news to his conspirators. Another question from 2005 bar exam. Paz Masipag worked as a housemaid and yaya of the 1-week-old son of the spouses Martin and Pops Coripot. When Paz learned that her 70-year-old mother was seriously ill, she asked Martin for a cash advance of 1,000 pesos, but Martin refused. One morning, Paz gagged the mouth of Martin's son with stockings, placed the child in a box, sealed it with a masking tape, and placed the box in the attic. Later in the afternoon, she demanded 5,000 pesos as a ransom for the release of his son. Martin did not pay the ransom. Subsequently, Paz disappeared. After a couple of days, Martin discovered the box in the attic with his child already dead. According to the autopsy report, the child died of asphyxiation barely 3 minutes after the box was sealed. What crimes did Paz commit? Explain. The answer: Paz committed the composite crime of kidnapping with homicide under Article 267 of Revised Penal Code as amended by RA 7659, and under the law, any person who shall detain another or in any manner deprive him of liberty and the victim dies as a consequence is liable for kidnapping with homicide, and shall be penalized with the maximum penalty. In this case, notwithstanding the fact that the 1-week-old child was merely kept in the attic of his house, gagged with stockings and placed in a box sealed with a tape, the deprivation of liberty and the intention to kill becomes apparent. Though it may appear that the means employed by Paz was attended by treachery, or killing the infant, nevertheless, a separate charge of murder will not be proper in a view of the amendment. Here, the term homicide is used in its generic sense and covers all forms of killings, whether in the nature of murder or otherwise. It is of no moment that the evidence shows the death of the child took place 3 minutes after the box was sealed, and the demand for ransom took place in the afternoon. The intention is controlling here. That is, ransom was demanded. Another topic is the crimes against property. Question: can there be a crime of robbery with attempted rape? The answer: the crime cannot be complex crime of robbery with attempted rape under Article 48, because a robbery cannot be a necessary means to commit attempted rape, nor attempted rape to commit a robbery. This is found in People versus Carriaga, CA 54 OJ 4307. Question: Jarvis and Marlon asked their friend Jonathan to help them rob a bank. Jarvis and Marlon were inside the bank but were unable to get any money from the vault because the same was protected by a time delay mechanism. They contented themselves with the customers' cell phones and a total of 5,000 in cash. After they dashed out of the bank and rushed into the car, Jonathan pulled the car out of the curb and hitting a pedestrian, which resulted in the latter's death. What crime or crimes did Jarvis, Marlon, and Jonathan committed? Explain your answer. This is found in 2007 bar exam. The answer: Jarvis and Marlon committed the crime of robbery while Jonathan committed the special complex crime of robbery with homicide. Jarvis and Marlon are criminally liable for the robbery only because that was a crime conspired upon and actually committed by them. Assuming that the taking of the cell phones and the cash from the bank's customers were affected by intimidation. They will not incur liability for the death of the pedestrian because they have nothing to do with it. Only Jonathan will incur liability for the death of the pedestrian, aside from the robbery, because he alone brought about such death. Although the death cause was not intentional but accidental, it shall be a component of the special complex crime of robbery with homicide because it was committed in the course of the commission of the robbery. Another question here. What is the criminal liability of a person who on the occasion of robbery kills a bystander by accident? The answer. The person is liable for robbery with homicide because the revised penal code punishes the crimes as only one indivisible offense when a killing, whether intentional or accidental, was committed by reason or on occasion of a robbery. Article 294, paragraph 1 of the RPC. This is found in People versus Mabasa, 65 Philippines, 568, 1938. Another question. What is essential for a conviction for the crime of robbery with homicide? The answer. What is for the prosecution to establish the offender's intent to take personal property before the killing, regardless of the time when the homicide is actually carried out. In cases when the prosecution failed to conclusively prove that a homicide was committed for the purpose of robbing the victim, no accused can be convicted of robbery with homicide. This is found in People versus Chavez, JR number 207950, September 22, 2014. Here in another question here from Bar 2014. Klypto went alone to a high-end busy shop and decided to take one of the smaller purse without paying for it. Overcame by conscience, she decided to leave her own purse in place of the one she took. Her act was discovered and Klypto was charged with theft. She claimed that there was no theft, as the store suffered no injury or prejudice because she had left a purse in place of the one she took. Comment on her defense. The answer. The defense of Klypto has no merit. Theft is already consummated when the moment Klypto took possession of one of the smaller purse inside a high-end class without paying for it. She took the personal property of another with intent to gain without the consent of the latter. Damage or injury to the owner is not an element of the theft. Hence, even if she left her purse in lieu of the purse she took, still, the theft is committed. Another question here. When is a crime of theft qualified? There are 6 elements. Number 1, if theft is committed by a domestic servant. Number 2, if the theft is committed with grave abuse of confidence. Note, if the offense is to be qualified by abuse of confidence, the abuse must be grave. Like an accused who was offered food and allowed to sleep in the house of the complainant out of the latter's pity and charity, but stole the latter's money in his house when he left the place. Number 3, if the property stolen is a motor vehicle, male matter, or large cattle. Number 4, if the property stolen consists of coconuts taken from the premises of a plantation. Number 5, if the property stolen is fish taken from a fish pond or fishery. Number 6, if property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbance. Okay, here's another case. Here's another question from 2014 bar exam. Madam X, a bank teller, received from depositor Madam Y a check payable to cash in the amount of 1 million pesos to be deposited to the account of Madam Y. Because the check was not a cross check, Madam X credited the amount to the account of her good friend, Madam W, by accomplishing a deposit slip. 7 days after, Madam X contacted her good friend, Madam W, and told her that the amount of 1 million pesos was wrongfully credited to Madam W. Thus, Madam X urged Madam W to withdraw the amount of 1 million pesos from her account and to turn over the same to Madam X. As a dutiful friend, Madam W readily acceded. She was gifted by Madam X with an expensive Hermes bag after the withdrawal of the amount. What crimes, if any, did Madam X and Madam W commit? Explain. The answer here is Madam X committed the crime of qualified theft under Article 310 of Revised Penal Code. When Madam X, a bank teller, received the check payable to cash in the amount of 1 million pesos for deposit to the account of Madam Y. What was transferred to her was merely the physical or material possession thereof. Hence, her subsequent misappropriation of the amount shall constitute theft, qualified by grave abuse of confidence. There is grave abuse of confidence because the relationship of guardianship, dependence, and vigilance between the depositor and the bank created a high degree of confidence between them, which Madam X, as the bank teller representing the bank, abused. Another question: what does fraud and deceit in the crime of estafa means? Answer: in Alcantara versus CA, the court, citing People versus Balasa, explained the meaning of fraud and deceit. Fraud, in its general sense, is deemed to compromise anything calculated to deceive, including all acts, omissions, and concealment involving a breach of legal or equitable duty, trust, or confidence justly reposed resulting in damage to another, by which an undue and unconscientious advantage is taken of another. It is a generic term embracing all multifarious means which human ingenuity can devise and which are resorted to by one individual to secure an advantage over another by false suggestions or by suppression of truth, and includes all surprise, trick, cunning, dissembling, and any unfair way by which another is cheated. While deceit means is the false representation of a matter of fact, whether by words or conduct, by a false or misleading allegations, or by concealment of that which should have been disclosed, which deceived or is intended to deceive another, so that he shall act upon it to his legal injury. That definition is found in Latio versus People, GR number 161651, June 8, 2011. Another question. Separate charges for estafa and illegal recruitment. It is settled that a person may be charged and convicted separately of illegal recruitment under Republic Act number 8042 in relation to the Labor Code, and estafa under Article 315, Paragraph 2A of the Revised Penal Code. The court explicated in People versus Cortez and Yabot that in this jurisdiction it is settled that the offense of illegal recruitment is malum prohibitum, where the criminal intent of the accused is not necessary for conviction, while estafa is malum in se, where the criminal intent of the accused is crucial for conviction. Conviction for offense under the Labor Code does not bar conviction for offenses punishable by other laws. Conversely, conviction for estafa paragraph 2A of Article 315 of the Revised Penal Code does not bar a conviction for illegal recruitment under the Labor Code. It follows that one's acquittal of the crime of estafa will not necessarily result in the acquittal of the crime of illegal recruitment in large scale and vice versa. That is found in People versus Ochoa, JR number 173792, August 31, 2011. Okay, here's another question. Sulina met with several people and gave the impression that she had the capacity to facilitate applications for employment as a factory worker in Japan in lieu of a fee amount to 20,000 pesos. These people believed Sulina paid the said amount. However, no such promise materialized and the money taken as a fee was never returned. Is Sulina guilty of the crime of illegal recruitment in large scale as well as estafa under Article 315, Paragraph 2A of the RPC? The answer, yes. Sulina is guilty of the crime of illegal recruitment in large scale as well as estafa under Article 315, Paragraph 2A of the RPC. It is settled that a person may be charged and convicted separately of illegal recruitment under RA 8042 and estafa under Article 315(2)A of the Revised Penal Code. In this case, all the elements of the crime of illegal recruitment in large scale are present. Number 1. The offender has no valid license or authority required by law to enable him to lawfully engage in recruitment and placement of workers. Number 2. The offender undertakes any of the activities within the meaning of recruitment and placement under the Article 13B 14 of the Labor Code or any of the prohibited practices enumerated under Article 34 of the said code, now Section 6 of the RA 8042. And number 3, the offender committed the same against 3 or more persons individually or as a group. Likewise, Sulina is also liable for estafa under Article 3152A of the RPC, while she defrauded the private complainants into believing that she had the authority and capability to facilitate applications for employment as factory workers in Japan in lieu of a fee amounting to 20,000 pesos in which the complainants complied with, resulting to their own damage and prejudice when such promise for employment never materialized. That case is in People versus Sulina, JR number 196784, January 13, 2016. Another question. Ernesto Pedili assisted his brother Wilson and his business partner Placido Gancho in purchasing construction materials for a project by allowing them to use his credit line in Mount Trail Farm Supply and Harvest. At the completion of their project, the business partners Wilson and Cancho heeded to the advice of Ernesto that their net income of 130,000 should be applied first to settle their balance to MTFSH and their entrusted and entire amount to Ernesto, with express instructions to pay MTFSH and deliver the remaining balance to them. Afterwards, Ernesto refused to give Cancho his share in the net income despite the latter's repeated demands. Is Ernesto guilty of theft or estafa? The answer: Ernesto is guilty of theft, not estafa. The court has consistently ruled that not all misappropriation is estafa. The principal distinction between the two crimes is that in theft, the thing is taken, while in estafa, the accused receives the property and converts it into his own use or benefit. However, there may be theft even if the accused has possession of the property, if he was entrusted only with the material or physical or de facto possession of the thing. His misappropriation of the same constitutes theft, such as in the case at bar. But if he has the juridical possession of the thing, his conversion of the same constitutes embezzlement or estafa. That is the case of Pedile versus People, JR number 163437, February 13, 2008. Another question here. Carganello was alleged to have entered a kasunduan with Teresita Lazaro, a rice trader in Nueva Ecija. Teresita gave the accused 132,000 pesos for the purpose of buying palay to be delivered on or before November 28, 1998 to Lazaro. To Lazaro Palay Buying Station. In their kasunduan, the parties agreed that for every kilo of palay bought, the petitioner shall earn a commission of 20 centavos. But if no palay is purchased and delivered on November 28, the petitioner must return the 132,000 to Teresita within 1 week after November 28. However, no palay was received on the agreed date and the 132,000 was never returned. Then Teresita made oral and written demands to the petitioner for the return of 132,000 pesos, but her demands were simply ignored. Is Carganello guilty of the crime of estafa? The answer, yes, all the elements of estafa are present. First, the money goods or other personal property is received by the offender in trust or on commission, or for administration or under any other obligations involving the duty to make delivery of or to return the same. The petitioner received in trust the amount of 132,000 from Teresita for the purpose of buying palay. Second, that there be misappropriation or conversion of such money or property by the offender or denial on his part of such receipt. There was misappropriation when petitioner failed to conform in their kasunduan, not delivering the agreed palay nor returning the 132,000 for such failure of delivery of the palay. Third, that such misappropriation or conversion or denial is to the prejudice of another. The acts of petitioner were to the prejudice of Teresita. Lastly, that there is demand by the offended party to the offender. Teresita demanded for the return of the 132,000, and this was shown in her oral and written demands to the petitioner. This is found in Carganello versus People, GR number 182424, September 20, 2014. Here's another case. Madarang went to Villanueva's residence and was able to sell the Villanueva 5 set of jewelry. Villanueva made out 9 checks, 8 of which were post-dated for the payment of such jewelries. Madarang received the checks because of Villanueva's assurance that they would all be honored upon presentment. However, the Joey Bank paid only one of the 8 post-dated checks since the remaining checks were dishonored on account of insufficient funds and account close. Is Madarang liable for estafa? The answer, yes. All the elements are present, in which the first element was admitted by Villanueva, who confirmed that she had issued the checks to Madarang in exchange for the jewelry she had purchased. There is no question that Madarang accepted the checks upon the assurance of Villanueva that they would be funded upon presentment. The second element was likewise established because the checks were dishonored upon presentment due to insufficiency of funds, or because the account was already closed. The third element was also proved by the showing that Madarang suffered prejudice by her failure to collect from Villanueva. That is in the case of People versus Villanueva, JR number 163662, February 25, 2015. Another question. Sato, through fraudulent misrepresentations, was able to secure the signature and thumb mark of Manuelita Gonzalez on a special power of attorney, and where his daughter is made attorney in fact and sold 4 valuable pieces of land in Tagaytay City. Estafa under Article 3153 was filed against him in RTC. Sato moved for the quashal of the information, claiming that under Article 332, his relationship with Manolita Gonzalez, his mother-in-law, was an accepting circumstances. Is Sato exempted from criminal liability under Article 332 for the complex crime of estafa through falsification of public documents? The answer, no. Sato is not exempted from criminal liability under Article 332 for the complex crime of estafa through falsification of public documents. The absolutory cause under Article 332 is meant to address only simple crime of theft, swindling, and malicious mischief. When the offender resorts to an act that breaches the public interest in the integrity of public documents as to violate the property rights of the family member, he is removed from the protective mantle of the absolutory cause under Article 332. This is in the case of intestate estate of Manolita Gonzalez, JR number 181409, February 11, 2010. Our next topic here is crimes against chastity. Okay, what are the elements of adultery? The elements of adultery is number 1. To convict a woman for adultery, it is necessary that A. She is a married woman. B. That she unites in sexual intercourse with a man not her husband. Number 2. To convict a man for adultery, it is necessary that A. He had a actual intercourse with a married woman. B. That he commits the act with the knowledge that said woman is married. Another here is elements of concubinage. Number 1, man must be married. Number 2, he committed any of the following acts. A. Keeping a mistress in the conjugal dwelling. B. Having sexual intercourse under scandalous circumstances with a woman who is not his wife. C. Cohabiting with her in any other place. Number 3, as regards the woman, she must know him to be married. Here's our last question for this part 5. AAA was about to enter the school campus with her friend when Kayanan, her brother-in-law, arrived on a tricycle and pulled AAA towards the tricycle. She tried shouting, but Kayanan covered her mouth. Kayanan brought AAA to a dress shop to change her clothes since she was in her school uniform, and later to a Jollibee outlet. Afterwards, he brought her to his sister's house and raped her inside a bedroom. AAA told her mother and brother of the incident, and she was shown to be suffering from depressive symptoms and presence of sexual abuse. Kayanan interposed the sweetheart defense and presented 2 love letters supposedly written by AAA. The RTC and CA convicted Kayanan of forcible abduction with qualified rape. Is Kayanan guilty for the crime of forcible abduction with qualified rape? The answer, no. Kayanan should only be liable for qualified rape. Forcible abduction is absorbed in the crime of rape if the real objective of the accused is to rape the victim. In this case, circumstances show that AAA's abduction was with the purpose of raping her. This is found in People versus Kayanan, JR number 200 80 July 18, 2014. It's the end of our part 5, and I'll be back for the part 6. Thank you so much for listening. I do hope I contributed something to help your criminal law review for the Philippine bar exam. I am doing this reading or audio to help also myself as I am struggling with my focus in reviewing the bar exam. I really find it hard to study, especially reading these notes, so I decided to make this video so that even if I am doing something or I am in public places, I still be reviewing the bar in my earphones. If you want also a copy of my reading audios, please send me a message, or if you want me to read some other bar reviewers in my email ad, sender5681@gmail.com, or to my Facebook page, sender5681. It would be a pleasure to help others while I am reviewing for the bar exam, and I am so happy to share these things to my fellow bar candidates. Thank you so much, and God bless.